Now it's my pleasure to introduce Professor Tara Righetti, who is joining us to talk about the legal and technical dynamics of carbon capture, utilization, and storage. Professor Righetti is the Occidental Chair of Energy and Environmental Policies and co-director of the Nuclear Energy Research Center at the University of Wyoming. She's a tenured full professor on the faculties of the College of Law, the School of Energy Resources, and the Hobbs School of Environment. Please help me welcome Professor Righetti.
Okay, John and I really should have coordinated because we have a lot of overlap, including some of the pictures. So I may kind of go off slides for a few of these things to make sure we're covering new things as we go through. So thank you for that great sort of foundation. So I wanted to start a little bit about kind of just going over what is CCUS. And I have to thank my colleague Fred for putting together these slides since he handles a lot of our technical things. But the objective is that you're going to capture carbon from either direct air capture or from a point source, but it has to be some source of anthropogenic CO2. You have to typically transport it. That can be in a pipeline or it could be through maritime transport. And then you're going to have to inject it and find a place to put it. And most of my research focuses on how do you get the rights and permits necessary to put the CO2 in the ground and keep it there forever. I think initially people thought about CCUS largely as relating just to decarbonization of the power sector, but it really is so much more than that. It's critical to alternative fuels, it's critical to hydrogen, and it's going to be absolutely critical, particularly to industrial decarbonization. And I mention that because things, for example, like process emissions that come from chemical processing facilities or mineral processing facilities. These create their own emissions that are independent from generation of heat and power. And those, if we're going to have net zero industrial products and net zero industry, there really isn't any way to have perfect efficiency without CCUS. So this really is critical, as John suggested, to meeting our goals. And you can see kind of, this is a variation on what he showed from Wood Mackenzie Group, but this whole blue sector on the bottom, those are things that only happen with some form of CCUS. So if you've heard of like BECCS, right? That's bioenergy with carbon capture and storage. So even if you're using a renewable source like wood pellets, you still need to capture those emissions. You might be capturing from ethanol facilities. And so you could be capturing from natural gas generation, right? There's a whole range of activities where capture can apply. So here's some of the commercial drivers that are making this happen. And John talked a lot about all of the incentives that DOE has created, but the two other ones that I really want to go into are 45Q. That's probably the one everybody's most familiar with. And it provides a tax incentive to encourage utilization and storage of CO2. And this has really created an explosion in interest in this. I think probably 2 years ago, there were, most CCUS projects were on a research scale and people were looking at this as something that could be viable in the future. The number of projects that have been suggested and applying for permits is just growing daily. So there's a few things that you have to do to qualify for 45Q. First, you have to have secure geological storage, and it has to be of a qualified carbon oxide. So secure geologic storage doesn't necessarily mean in a saline storage. It could be in unminable coal seams. It could be in maybe basaltic formations. But to be a qualified carbon oxide, it has to be captured as an industrial source and would otherwise be released. But they have defined this to include DAC as well, even though it's not a point source capture. capture. The volume on which you can claim your credits is going to be based on a life cycle analysis of your GHG emissions. So you have to measure it at the point of capture, and you measure it again when you're injecting it. So you make sure you don't lose any in the transportation process. And then you have to have, very extensive monitoring processes in place to make sure that it's staying contained and you're not losing it. And there's actually a clawback in that credit that if you end up having a loss of containment, you could have to give back the money you get for storing because it's no longer stored. So there's new credits for DAC, for geologic storage, and I mixed up the numbers here. It's $85 a ton on geologic storage and $60 a ton for CO2 EOR. Why is it less for CO2 EOR? When we think about this, I think there's a couple different reasons for this, right? First, you're getting the oil out, and that has a value. So you are often recycling CO2, and you can only claim your credit for the part that isn't getting recycled and recaptured. It's the part that gets permanently stored. And I think there's ways that EOR operators within their leases can maximize the amount that is stored. And try to increase that storage quantum, but you're trying to make incrementally recoverable oil come out of the ground, and then you're able to sell that into the market. So the other reason I think the credit's less is because, there is that net impact, because when the oil comes out of the ground, then when it is combusted, that creates emissions, right? So there's less of an incentive for EOR than there is for geologic storage. And then the biggest credit is for DAC, not because it creates a bigger climate impact, right? A ton of CO2 is a ton of CO2, no matter how you capture it, but because DAC is just like so massively expensive that it needs more money to be viable. Going forward, it encourages use of anthropogenic CO2, though, compared to natural sources of CO2 in EOR. So, some of the CO2 that is used in enhanced oil recovery and other industrial processes is actually mined for and drilled. There's several large places. This often surprises people, right? So we have federal lands where we actually drill for and produce a lot of CO2 and get royalties paid on that. And then you can get a credit for putting it back in the ground, but you can't put the natural CO2 back in the ground and claim the credit after having pulled it out, right? So there's some sort of netting here that would have to happen. And then there's also opportunities to monetize carbon removals in voluntary markets. So those markets are not regulated. They're created through sort of voluntary, not compliance carbon credit mechanisms. So if anyone, when they buy their plane ticket, they say, hey, do you want to pay more for your plane ticket to offset your emissions, right? What the airline company is likely doing is buying voluntary credits in the market, saying, we will pay someone else to reduce CO2, and then that can be permanently retired, and that will sort of offset the impact of this industrial activity. A lot of these credits are generated through nature-based solutions and land use type things, but often there's a higher value for credits that could be generated through CCUS because it has more permanence than something necessarily like a forestry project could have. So I won't go through this because John did, but there's a ton of public investment right now in projects and R&D. I think I just want to emphasize what a big shift this is. I think it's a big shift, not only in terms of what happens in CCUS, but just a shift in general of how we're approaching energy development and energy policy, where we really are having much more public-private partnership to bring these projects into being. So what is your qualified carbon oxide? I went through this a little bit. So here's the definitions from section 45QC1. So it says, any carbon dioxide that's captured from an industrial source that would otherwise be released into the atmosphere and is measured at the source of capture and verified at the point of disposal. So there is this sort of additionality requirement, right? It has to be something that would otherwise be released. If it wasn't going to be released to begin with, you can't claim it as a qualified carbon oxide and then get the 45Q credit for injecting it. If it's direct air capture, then it's any CO2 that is captured directly from ambient air, and it's measured and verified. And then 45QC2 says that for EOR projects, it includes the initial deposit of captured carbon dioxide used as a tertiary injectant, but doesn't include the parts that are recaptured, recycled, or re-injected, right? So often you have a process when you're doing EOR where you put the CO2 in and then you take as much of it as you can out so you can reuse it. And that makes sense because this is a commodity, right? We think about CO2 as a waste, but if you're doing EOR, it's also an expense. It's something you have to buy for your project. So you might re-inject the same CO2 numerous times in the course of a project, but you can only claim that once, right? You can't say you're injecting it for permanent storage if you're taking it back out and reusing it. So CO2 is also, or CCS is also being considered as the best system of emissions reduction. And this is in the new source performance standards that have been released as a draft rule by EPA. And it says that the use of CCUS could achieve 90% capture of GHG emissions by 2035. They also look at a best system of emissions reduction as being co-firing with low GHG hydrogen. Most of that low GHG hydrogen is going to be created with CCS. That's why it's low GHG. So I think you look at this and this shows that if this rule goes forward, CCS really becomes kind of an existential question, not only to achieving our climate goals, but also to what it looks like to continue operating fossil fuel-fired generating stations. There's a lot of questions about how this is actually going to work, because even if you were able to install perfect capture equipment that captured 100% of the CO2, you have to have a place to put it, and you have to have a way to get it there. And so until we have sort of commercially operating storage facilities where people are off taking the CO2 and transporting it and storing it for companies, this creates sort of a very big challenge to implementation of these rules. So this is the same thing that John showed on CO2 pipelines. Recently, like in the last couple weeks, we had PHMSA come out and they're doing some rulemaking. That's the Pipeline Hazardous Material Safety Administration. They are looking at the rules for CO2 pipelines, acknowledging that we're going to have this massive expansion, right? We have around 5,000-ish kilometers of operating CO2 pipelines available right now, including the one you see on Wyoming that's already built. They're envisioning this map, which doesn't show any new CO2 pipelines in Wyoming, so I don't think it's totally right. Envisions at least 100,000 kilometers more of CO2 pipelines being built within the next 20 years. So you have offtake agreements that are being entered into currently as sort of midstream companies look at trying to build this out, but it is not necessarily going smoothly. And I think this, in some cases or in some instances was a mistake, because there was this expectation that like people hate oil pipelines because they hate oil. But it turns out that people don't like eminent domain and pipelines, no matter what they're carrying. And there's been a lot of opposition to building these CO2 pipelines and making things like the 111 rule feasible, and reaching these climate goals is dependent on that happening. So I think this is going to be something that's very difficult, and we're going to have to reconcile with, right? Our desire for clean industry and our hate for clean infrastructure. Okay, utilization. This is where it gets kind of interesting is the ability to use CO2 and EOR, carbon-based products, synthetic fuels. So EOR injections are permitted under Class 2. You do that under your oil and gas lease. You don't need any new land rights to do EOR. It's already covered. Your MRV plans are approved under Subpart UU. And then there's this part in 40 CFR 146.4 that would allow you to expand the aerial extent of your aquifer exemptions from an enhanced recovery project to allow to conversion to Class 6. So how is utilization defined? It says, utilization of a qualified carbon oxide means the fixation of such qualified carbon oxide through photosynthesis or chemosynthesis, the chemical conversion of such qualified carbon oxide to a material or chemical compound, or the use for some other purpose as well, right? And then they have sort of the EOR is separated out from utilization for non-EOR purposes. So what are these things actually looking like? Mostly this is just happening right now on, I would say, a demonstration scale. Like Zara came out through LanzaTech with a dress that was made from fabric that was made from captured CO2. I think they only made one because I was like, I have to buy that. But then I couldn't find it anywhere. And then, you also see on sort of more interestingly, the idea of maybe taking captured CO2 and being able to make synthetic fuels that could become like new sustainable aviation fuels. So the ambition here is really cool because it's a circular economy model where you are, instead of just throwing the CO2 away and treating it as a waste, you're actually recycling it and sort of fixing the CO2 in products that can be reused, which would then limit the need for certain new raw materials. You have to think about a lot of things with that, including what are the energy and water inputs to make that do. And then eventually, everything gets thrown away somewhere and has to go somewhere. So what happens at the end of that? So to do geologic storage, one of the things that you're going to have to do is pore space acquisition. So the US is unique in this space in that we have private ownership of the subsurface in a lot of the country, or we have federal ownership in some places. Pretty much every other country in the world treats the subsurface as belonging to the sovereign. And so if you want to do a CCS project, you're going to go have a negotiation with the state for use of the subsurface. But in the US, it's owned privately, and Wyoming has declared in its statute that it's owned by the surface owner unless it was previously conveyed. It specifically says that there are no implied rights of surface use associated with that, and a number of other things that make it different from a severed mineral interest. So it's important to read through that whole statute as you look at this. And at least as of today, although I've heard that this may be up for debate, you can sever out the pore space and convey it to somebody else. So you could actually own just an interest in the pore space without owning the surface or the minerals. We allow amalgamation of pore space units through our unitization statute. And then we say that the CO2 that is injected remains the property of the injector. There's also a provision that says that the landowner or the pore space owner is sort of relieved of any liability for what happens to that CO2. This creates some interesting acquisition issues. First, right, you're going to have to get the rights from the people who own this to be able to inject in it. There are a lot of kind of sticky issues about, well, what happens when the CO2 migrates? Because it will. Does that create liability for subsurface trespass? That's a very interesting sort of academic question, but I think, even beyond that, one of the biggest considerations is to make these projects work, it's very important to have exclusivity in a very large area. And the best way to get exclusivity is to get the land rights in that area. Why is exclusivity important? That comes back to our Class 6 regulations, which really don't contemplate the possibility of multiple different parties injecting into the same formation at the same time or in different timeline horizons. Like, how can you show plume stability if you have other people who are concurrently injecting into the exact same formation? So the desire to have kind of exclusivity over an area where you're going to have your CO2 plume is really driving a lot of the pore space acquisition activities. And it's actually necessary to show that you have control of the area where you're going to put the pore space in order to get some of those permits. So here are sort of two pore space acquisition agreements that have already been approved. So if you want to take a look at what these look like, they're both publicly available. They're agreements with the state land office and cover collectively around 15,000 acres. So you can get those off the state land website, and get a sense of kind of what the commercial terms and structure of these agreements look like. Next thing you're going to have to do is some site characterization. So you have your pore space and you have these subsurface rights. Now, how do you figure out if it's going to be any good for storage? There's all these different tests you have to do. From a legal standpoint, right, you're trying to demonstrate that this is an area that's suitable for CO2 storage and capable of permanent containment of the CO2 you're injecting. From a legal standpoint, it's interesting for a couple different reasons, right? First, you might have to do something like shoot seismic. And I would encourage people, if they're thinking about this, right, there's a lot of like companies who have shot seismic surveys and they'll like sell them to you. But if they got only the permission of the mineral owner when they shot those surveys, and this is data that would be exploring for the surface, I think that's something you want to look at, right? Did they obtain the geologic data after having obtained the exploration rights from the correct party? If pore space is an interest that's owned by the surface owner, the mineral owner likely cannot consent to its exploration. Another thing you're going to have to do then is maybe drill like a stratigraphic test well or a geologic characterization well. That's going to require a permit to do so. And then you might have to run some tests, right? Injection tests or logging or things like that, which could also require authorizations or filing a sundry notice. Then you finally get to your permitting process. So most wells, right, are covered under Class 6. That's your geologic storage statute under the UIC program. Wyoming has primacy for that. There are several, at least 2 applications that have been filed in Wyoming if you want to take a look at the DEQ's website to see what those look like. I think at least one of them is open for public comment. So very interesting. That's kind of the main pathway that's contemplated. It's very robust in terms of its characterization. It's very robust in terms of its monitoring and reporting and verification and financial assurances. But the other pathway that you can go through is through injecting of pre-combustion oil and gas wastes. Those get injected into Class 2 wells and aren't subject to any of those same requirements for the most part. So this is ExxonMobil's Chute Creek Treating Facility, Subpart RR Monitoring, Reporting, and Verification Plan that kind of talks about what they're doing there under a Class 2 well, as you can see, and it sort of identifies where those wells are. That's currently the largest project in Wyoming, I think, in the country. I'm looking to see if Holly or John nod, and are able to kind of inject under the Class 2 program for that. It's a much faster pathway, but you can only inject oil and gas wastes. And so that's the limitation. I want to point out something that I think is a very arbitrary distinction that makes no sense, is that as probably most of you are aware, you can get aquifer exemptions for a Class 2 well. The same thing is not available for a Class 6 well. So you can inject CO2 under either of these programs. into, into the subsurface, but one of them is able to get an aquifer exemption, the other isn't. But the risk to underground sources of drinking water is, the same. So I think this is kind of an arbitrary distinction that makes a lot of areas unavailable for development, because otherwise you need to show that your formation meets the salinity requirements, which can be very high, even if it's a formation that maybe otherwise wouldn't qualify as a USDW and would never be used for, because of like commercial producibility, sort of flow rate economics issues. MRV is a huge part of this as well. There are two aspects of MRV. You have MRV obligations that come from the GHG reporting program under the Clean Air Act, and you have MRV requirements that come out of Class 6. So this means that you're going to need to have maybe conducting seismic, have monitoring wells, and you have to sort of have ongoing reports relative to potential sort of emissions from the facility or losses of containment. This is under Chapter 24, Section 14 for the Class 6 program. And then I've put in here sort of 40 CFR 98.448 for the GHG reporting program. How do you deal with liability? I know I'm in my last 2 minutes. So there's some kind of questions. I've put up 2 Wyoming statutes here. The one on the right, if it's showing up the same way to you as for me, basically says the injector, or the one on the left says the injector holds all of the liability for the CO2 they put in the ground. The one on the right, though, allows a certification of project completion, a release, and a transfer of title and custody to the state upon meeting certain conditions. So in Wyoming, the state has agreed to take on the long-term responsibility for these CO2 plumes. If the injector has really proven that the project, is in compliance with all laws, that they've addressed all pending claims, and that the plume is no longer expected to expand, that it's stabilized. This is really important for sort of understanding the way commercial models work for these projects, how insurance works for these projects. I would say this probably doesn't transfer liability for absolutely everything. If you look here, it says, looking here that they would take over title to the CO2. I don't think they're saying they'll take over all civil or contract claims that had sort of accrued or might accrue under private agreements. So you kind of have to tie up everything in a nice box before you're going to be able to transfer liability and get to that point. I think this is great, though, because it really puts an objective, right, that encourages excellent long-term stewardship up to the point of transfer. One of the problems we've seen, right, is that after you finish maybe producing the majority of oil, there are less incentives to be a good steward of the land long term. But here, because the only way that you're allowed to transfer liability is by really making sure you're in compliance with all laws up to that point, that you're monitoring it, you can prove that you've maintained containment, you can maintain and prove the stability, and you've resolved your claims on it, that's going to be a huge encouragement of good stewardship over the long term. Okay, that's it. Thank you. Happy to answer questions if we have any time, but I think we don't. So.